My book on common law originalism is really aimed at trying to critique and also reconstruct the originalist mode of constitutional interpretation. So what the book tries to take seriously is the transition that a lot of people in the founding generation were going through, whether they're people who drafted the Constitution or people who ratified it, between a really largely unwritten British style of constitutionalism and a written American Constitution. And what I look at is the way in which the common law, which was unwritten but included various kinds of statutory protections as well, really was included under the new framework of the Constitution, and how it really shaped how early Americans thought about rights, but also thought about the structure of government, despite their efforts to make a break from the British system. And I think that taking this common law background of the Constitution seriously causes us to call into question some of the tenets of traditional originalism. So the common law was the tradition in England that's composed of the cases and judicial decisions, but also of fundamental statutes like Magna Carta. The idea about common law was that it was a law from time immemorial, according to what the jurist said, but it also was a flexible vehicle that accommodated legal change. Common law in the 17th century and 18th century was thought to protect the rights of the subjects against incursion by either king or parliament. My book contends that actually citizenship is the one area where the common law actually has a fairly unified understanding across colonial and English contexts. Of course, there weren't citizens in England, there were only subjects, but everyone in the founding moment goes back to a fundamental case from the early 17th century called Calvin's case, which decided that those born within the jurisdiction under the jurisdiction of King James I of England, even though they were born in Scotland, because he was also King of Scotland, were born and could inherit within England. So this case really is a fundamental case that the members of the founding generation hearken back to, both in terms of the understanding of natural-born citizen and in terms of other debates about citizenship around the time of the founding. And then it's repeated, in fact, again, within debates about the 14th Amendment and what the 14th Amendment Citizenship Clause should mean. So a lot of the recent attacks against this idea of birthright citizenship by President Trump and the notion that anyone born within the United States of a foreign parent, of a foreign mother, shouldn't necessarily be a citizen, really are inconsistent with any form of originalist understanding of the Constitution. So I think that one of the problems of a lot of originalists today is that there's a view that a determinate meaning can be obtained. If we just go into the historical archive sufficiently, we'll get what the Confrontation Clause really means. Now, my argument is that actually that's not true, because people ratifying the Constitution had a lot of different understandings of what particular common law rights, like the right to confrontation potentially, would mean. And so even if we go into the history as much as possible, we're not going to get a determinate meaning. Now, for some people, that would be the end of originalism, right? They would say, why do we need originalism if we're not going to get this determinate meaning? I think actually it provides an interesting opportunity and an important democratic opportunity for contestation about the meaning of the Constitution. Diversity of common laws that are in the background of the Constitution are taken seriously allows us room for debate about the Constitution and important civic contributions to how we should understand our Constitution.